Yes. इसको देखा ना पहले देखो ठीक है सर आइटम नंबर 19 2019 matter. Okay. Both sides are represented on the prayer made by Land Council for the petitioner. List after 2 weeks. Yes. 18. Okay. Same order. "27 is a review petition. We will have to take it up and then pass orders. You wait till the matter is called. No, we don't know, but since it's a review petition, we have to take it up. "26. Same order, 2 weeks. Okay. 13. Okay, 13 and 34. 2 weeks. 34 is review. We'll have to take it up. Review is not being adjourned, only 13. 34 we'll have to take it up. Item number 2. Okay, same order, 2 weeks. Item 2. 9. Okay, same order.
Daily list item 1 for motion.
Have you applied? You haven't applied yet. Why didn't you apply and keep this pending? Do that. Do that petition. You will have no benefit consultation. I told you the last.
May it please, your lordships. The petitioner was declared to be a foreigner post the stream, your lordship. The petitioner's father, Kailash Burman, his name appeared in 1966 voters list as well as in the NRC, your lordship. And the name of the mother was also there. Thereafter, lordship, the petitioner during the trial, your lordship, he adduced the evidence of himself as PW1 and his maternal uncle as PW2, your lordship. The tribunal disbelieved the statements and the averments made by the maternal uncle because he did not state about his maternal uncle in the WS. This was the case, your lordship. There was an interim in my favor already. The
But there's a
petitioner,
long gap from after 66. Next document you have is of 1997.
97. 97, your lordship, there are two.
Casted your vote for the first time with your mother in 1997.
1997. That is why I have exhibited 97, your lordship. The mother's name is also there, and the petitioner's name is also there. In the previous one, both the mother's and the father's name was there, your lordship. And the maternal uncle, the brother of my mother, who had already expired, the maternal uncle deposed as PW2. And the maternal uncle in his deposition stated that we are 5 brothers and sisters. But that aspect was not stated by the petitioner in his WS. That is the reason it was disbelieved. There is another aspect, as I was also discussing with my learned friend. I would like to apply under the provisions of CAA, your lordship, if that will be permissible, your lordship. I'll instruct my client to that effect.
But after the opinion, can you do so?
That is not.
I don't think there is a relaxation after the opinion is passed.
Have to withdraw this and then apply, lordship. So I have suggested he can apply, and if he finds some option favorable to him, then he can then withdraw this petition. Because there the documentation would be much less, lordship, as per the new rules.
So you don't say anything, we merely adjourn it on his prayer.
Yes, lordship, my friend can, and on the next occasion, if there's nothing happening, lordship can take it up on merit.
But we are just listing it in the admission column, because in the motion column, we find very difficult.
State Commissioner.
Both sides are represented. Pursuant to order passed earlier, the records of the tribunal is received. In view of the projection made in the writ petition, the court is inclined to issue notice of motion returnable. We will date after 2 or 3 weeks. Returnable on so and so.
Lordship, first week of January.
She'll give a date. Based on so and so. Accordingly, this is the matter in the admission column on so and so.
Item 3 for motion.
Implement order mirror Yoshimi kindly see annexure 6 page 54.
Page
54. Starts.
heard. Mr. A. Rashid, learned counsel for the petitioner and so for the respondents. Next one, please. Page 54, opinion dated 38/2025, passed by so and so in so and so. Thereby declaring the petitioner to be a pardon of post 25/3/1971 stream. Notice returnable in 4 weeks, extra copies within 2 days, call for the records. The prayer for bail is opposed by the learned standing counsel for the FT matters. Pursuing the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Walpara. List of points on the city of records.
Item 4 for motion.
May it please your lordship. My lord, impugn order is at page 29, lordship. It's a contested matter, lordship.
2019,
Yes, lordship.
you have to contest us on maintainability.
Yes, lordship, may I submit on that? Lordship, I'm now appearing as a legal aid counsel, lordship. Initially, he has approached a counsel and where he made also the fees, whatever, but the counsel had not filed the petition. So he, even last year also, he made certain payments to the lawyer. So, but the lawyer has not filed it. And thereafter, he didn't have any other resources. So he has now approached the Legal Services Authority, Lordship. So now I am appearing as a legal aid counsel, Lordship. Although I have not annexed, even he has paid through GPay, these all transactions are also there with him. But I have not annexed along with the writ petition. And even all the certified copies initially, when he has applied for in the year 2019, originals are with their lawyer only, Lordship. Again, this time he had to, he gave me the Xerox copy and there were missing few pages. So again, he had to apply this year, the certified copies, and thereafter this writ petition is filed, Lordship.
That can't be a good ground.
Understood, Lordship. His mother has adduced evidence, Lordship. At least at this stage, if records may be called for, Lordship.
Team. Next. The learned standing counsel for the FT matters has opposed the clearing the writ petition on the ground of inordinate delay in approaching the court. Next paragraph, keeping the issue of maintainability open. In view of inordinate delay in assessing the opinion dated 21/10/2019. Issue notice returnable on. Give a fixed date after 4 weeks. Returnable also. Extra copies within 2 days. Call for the relevant records for the cabinet the following. Sending requisition to the following email address of the learned tribunal. Prayer for bail shall be considered on receipt of the tribunal's records. List of so and so.
19th of January.
Deeply obliged, Lordship.
Item 5 for motion.
May I please, Lordships. This is contested matter, my lord. So kindly have it look at page 86, impugned order, my lord. Page 86, my lord.
Two item numbers idea, sir.
Mr. S. Ahmed, learned counsel for the petitioner and so and so for the respondents. Opinion is at page 86, dated 22/5/2023, passed by so and so in FT case number so and so. On DT case number so and so. Thereby declaring the petitioner to be a foreigner of 425 to 90th Century Spring. If you notice, returnable on same 19/1/2026. Extra copies within 2 days, call for the reports. By sending requisition to the following email address of the learned tribunal.
Order, yes, sir.
Next, the prayer for bail shall be considered on receipt of records. List on so and so.
Obliged, please. Much obliged.
Item 6 for motion.
Yes.
May I please, your lordship? My lord, the impugn opinion at page 56, my lord. My lord, this is a, my lord, order of 2017, my lord. After filing the WS, my lord, he could not, he appeared, my lord, but he made an application for adjournment to adduce his evidence, but that was rejected. Page 56, my lord.
Okay, and Mr. S. A. Ahmed, now counsel for the petitioner. And so for the respondents. Opinion type copy is at page 53. And certificate copy is at page 56. Opinion dated 15/11/2017, passed by so in FT case number so, thereby declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable on 19/1. Extra copies within 2 days. Call for the relevant records from the concerned tribunal. Within the decision, it was following email address of the tribunal. Next. Where just in view of the inordinate delay in sending the written opinion dated 15/11/2017, keeping the issue of maintainability open, issue notice returnable on so. Next, prayer for bail shall be considered on receipt of the tribunal's records. List on so.
Oblige me.
Item 7. Item 7.
None appears on call for the petitioner. However, Mr. S. K. Zarikal, our government advocate, is present. Next, madam. The case projected by the petitioner is that the police personnel from Ranguli, RANGJULI, police outpost under Lakhipur police station had come to the residence of the petitioners on 18/9/2025. Comma. Searching for them, Mr. Power, comma. The but except for the fact that one Razia Khatun of village Hatishila, HATISHILA, Muslim Para, had lodged an FIR on 15/9/2025 at a Rongchuli
Yes.
police outpost. On the basis of which no FIR was registered. The police personnel did not disclose pendency of any case against the petitioners. Accordingly, the present writ petition has been filed under Article 226 of the Constitution of India. Next paragraph. The learned counsel for the petitioner shall provide a copy of the writ petition along with a soft copy of the writ petition with all enclosures to the learned government advocate in course of the day to enable him to obtain instructions. Next, upon receipt of the copy of the hard copy and the extra copy as well as the soft copy of the writ petition from the learned government advocate shall obtain instructions. So whether the petitioners are required in connection with any case laws against them. Stop the information shall be provided to the court through the learned government advocate. Next paragraph. List on 15 2025. You are the Mr. At the presence of Mr. J. Ahmed. Give a copy today. Next Monday, we are fixing soft copy and a physical copy of the writ petition.
In the no coercive action.
No. You may have murdered some 10 people. We don't know.
If I got the information, we will appear.
For that, you'll have to move the court for bail.
No, if we got the number, then we will move the argument. But we have not got any number. There's no number.
Item 8 for motion.
May I please, your lordship? Lordship, order is at page number 42. Lordship, in this, we are also praying that he, to get a chance for cross-examination.
Let us see, we are keeping the issue of maintainability open at this stage.
Chip.
Mr. J. Sindel and counsel for the petitioner and so for the respondents. Opinion is at page 42, dated 14/8/2019. Passed by so-and-so in FT case number so-and-so. Corresponding to D case number so-and-so, thereby declaring the petitioner to be a foreigner of 25 circular street. In view of the inordinate delay in selling the opinion dated 14/8/2019, keeping the issue of maintainability open, issue notice returnable on so-and-so. Extra copies within 2 days. All for the records, the following email address. Prepared for bail shall be considered on receipt of the travels reports. List on so-and-so.
Obligation.
Item 10 for motion.
Yeah, on impugned order, page 38, my lord. Page 38, order dated 31/5/24.
Third, Mr. A.W. Aman and counsel for the petitioners and so-and-so for the respondents.
Yes.
Against a senior citizen.
Opinion is at page 38. Dated 31/5/2024, passed by so-and-so in FT case number so and so. There are three references, FT case number so and so, FT case number so and so, and reference FT case number so and so. Thereby declaring the petitioner to be a foreigner of 1971 series. Notice returnable on so and so, extra copies within 2 days. Call for the relevant record from the concerned tribunal for the email address. Next one, the prayer for bail shall be considered on receipt with the tribunal's records. Next, list on so and so.
Item 11,
May I please lordship the impugned order lordship the page 86,
Page
86 lordship, the contested case lordship. Order dated 30/10/2021 lordship. Delay due to lordship the
Mr.
his mother is expired lordship.
And
in cancer
other running counsel for the petitioner. And so also for the respondents. Is at page 86, dated 30/10/2021. Passed by so and so in FT case number so and so, FT case number so and so. They were declaring the petitioner to be a foreigner of post 25
Metro.
Central Street.
four.
Notice returnable on 19/1. Extra copies within 2 days. Call for the records of the following email address. Here also it is 2021. In view of the inordinate delay in challenging the opinion dated 30/10/2021, keeping the issue of maintainability open. Issue notice. Next, prayer for bail shall be considered on the receipt of the tribunal's records. Next, list also well so.
Diploma.
item 12 for motion.
My lord, in this case, my lord, it's a contested case, my lord, or impugned order is at page 12, my lord. Order was passed on, my lord, 23rd of September this year, my lord. At page 12, my lord.
Right. Mr. SSS Rahman, learned counsel for the petitioner. And so for the respondents. Page 12, opinion dated 23/9/2025. Passed by so and so in FT case number so and so, SP reference number so and so. Thereby declaring the petitioner to be a foreigner of post 25 96 Street. Notice returnable in 4 weeks, extra copies within 2 days, call for the records. Here, the following email address of the learned tribunal. Prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection, 10 days time to take bail of ₹5,000 to the satisfaction of Superintendent of Police Border, Nagaon. List after 4 weeks on the sit of the house.
Right.
My lord, I'm sorry, my lord, item 7, 16 may be fixed, my lord. 16 or 17, 16 or 17.
Okay, 16, make it 16.
Supplementary item 45 for motion.
I was supposed to take instruction for BSF authority, Malad. I have the instruction, Malad, written instruction, Malad, on the intervening night of 27 May, Malad. He along with other 108 numbers of person, Malad, sent back to Bangladesh, Malad. All are declared foreigners, Malad. I have a list also, Malad, the authority, Malad. In this list, Malad, there is a list, Malad, last page, Malad, serial number 108. Total 109 numbers of persons were handed over by the BSF border police, and he is at serial number 108 for the values.
Yes, Mr. Chauhan,
My lord, can you see page 35, my lord? Annexure 12.
35.
Yes, 35. My lord, on 18/7/25, and 18/7/18, my lord. An opinion was passed, my lord, by FT Tezpur.
Yes.
Whereby he has been declared, my lord, as foreigner. He, my lord, for his innocence, or my lord, for poverty, my lord, he could not, my lord, take a step against this order, my lord. So, my lord, he should be given at least some.
Mr. Chauhan, he has been sent back to the country of origin.
Yes, my lord.
Now, what right would he have to challenge the opinion?
My lord, he is permanent resident of this country, my state of Assam.
Once it is sent back, then he doesn't have a right to challenge it. How can a non-citizen challenge the opinion?
My lord, but this order, my lord, the opinion, he could not challenge, my lord, the opinion at that point of time, my lord. For his poverty, my lord.
No, that's okay.
That should not be
You see,
needed,
that
my
would
lord.
mean that
for
the
his-
order has attained finality and has been deported. Once he is deported, the person would not have a right to challenge it.
But it should have been, my lord, given some opportunity to challenge this, my lord, order.
He had ample opportunity, lordship, all these years, almost 9 years.
Mr. Chauhan,
That is very, but my lord, only the reason for which my lord, then I'll satisfy with lordship on next day, my lord.
Lordship, there's nothing left in this petition now, lordship.
Yes, my lord, I'll try my
Lord-
best.
412 lordship. Serial 142 Chasila Nam.
Next week on 28. Malak, in terms of the earlier order, Malak, 2111, Malak, 412, which was, Malak, I have not bring the record, Malak. Malak, I have take the instruction in terms of order date 211125.
2111 to patient. 2111. Okay.
Then. Malak, the opinion is also ex parte opinion, Malak. It's not contested, Malak. Ex parte opinion. Obliged.
Supply item 46 for motion.
May I please, your lordship? My lord, the mother of the petitioner was arrested on, my lord, 25/5/2025. আছে না এখানে ভিতরে না ভাই না ভিতরে আছে না ভিতরে
আছে ইয়াতে আছে।
ইয়াতে
Actually, this is a common instruction for items. The next three items, Lordship, WP and WPC, 77, 78, and 79, Lordship. Yes, Lordship.
The learned standing counsel for the FP and border matters has produced written instructions dated 5/12/2025. They were informing the court that the mother of the petitioner, namely Musammat Halima Begum, HALIMA Begum, was taken into custody on 25/5/2025. Pursuant to the adverse opinion by the concerned foreigners tribunal, she is presently being held at the holding center, 7th AP Battalion, Saraikhola, Pokrajhar. Accordingly, the court is inclined to permit the petitioner, namely Ashma Begum, ASHMA Begum, and one family member, the visitation right to her mother, namely Musammat Halima Begum, at the holding center referred above. Next, accordingly, it is provided that on production of a certified copy of the order before the in charge of the holding center, 7th AP Battalion, Saraikhola, Pokrajhar, the said authority shall permit the petitioner and one family member to meet the detained foreign national, namely Musammat Halima Begum, and to obtain her signature in the Wakalat Amark. Next para. list on so to enable the petitioner to inform the court as to whether the petitioner has been able to meet mother. Next paragraph, list on 15, 25. So, 46.
Oblige. Same one, didn't I?
Item 47.
Common instructions produced in WPC criminal 77 of 2025, 78 of 2025, and 79 of 2025 is made a part of record. Huh? Item 78. Yes,
Serial two, Lordship.
serial 2.
Yes.
Okay. No, she's not saying, this is serial number 3. Muhammad Dilwara Khatun.
Dilwara Lordship.
Dilwara is item serial number 3. Same. Same order. इसमें instructions का बात होगी. Okay, same order here.
Okay, follow the no? I could this settle. Muhammad Asiruddin.
Nasir.
Huh? The next to Taliban.
Item 48.
Yeah, petitioner.
Lordship,
Farooq Ali.
serial two has
Just-
two
just a moment.
petitioners.
Just a moment.
Serial 2 and 3
2 and 3 in this petition, Lordship.
in item number, Lordship. 47.
47, there are
47, there are two petitioners, ex parte order, Lordship.
Parents of the petitioners.
You
Okay,
should
okay.
have filed two cases. You made a mistake of filing one.
Asiruddin also, okay.
Lordship.
Here this will be in 78. Here, there are two persons registered. One is Mohammad Asiruddin, ASI RUDDIN, and Muhammad Dilwara, DILWARA KHATWN. These two were taken into custody. And the petitioner's name is Farooq Ali, FARUKAALI. Farooq Ali.
Lordship. I may be allowed to take signature on Lokalat no, Lordship.
Everything,
Obliged.
sir.
Same order.
48.
Yes, my lord. Son of the detainee is the petition.
This is 79 is serial number 4. Name of the arrested person is Muhammad Nasima,
Nasima Begum.
Begum. The name of the petitioner is Miraj, MERAJ, Miraj Ali. Same order.
Obliged.
Supplementary item 49.
Yes,
These are contempt. If your lordship is kindly take up item of 50 mile, all this.
50.
50 I have marked, that's why.
All similar.
All similar matter, all similar. My lord,
Yes,
all these petitioners belong to the category of Assam Police Service. So Lordship will please take it mind. This is not an Assam Civil Service Transport Department, it is only APS.
2015.
Of, my lord will kindly note, of 2013 they appeared entrance, and 2015 they were appointed. Now please take the judgment of your lordship at page 22.
Yes,
And if your lordship kindly see at page 28. 28. Link is WA 333 of 2021. Lordship got it? And see kindly how many petitioners are there. There are about 8 petitioners. 8. 1, 2, 3. Second page.
4 and 6.
Except 4 and 6. All are there before this court. Except 4 and 6.
Now in the contempt.
In the present contempt application. Now please turn to page 62, my lord. Page 62. I'll take a bit of time, my lord, because it will make clarity will be there. Page 62. If your lordship looks upon writ appeal, that 333, kindly see, Mr. Das, my name appears. Lordship got it?
Yes,
Column, my name appears, and writ appeal 96, 333, we are concerned about 333 of 2021.
yes.
Now, please turn to again at 64. Now, please see the judgment.
Oh. Taking us through documents will have to be, the matter has to be adjourned. Because in this matter, Mr. D.K. Mishra appears and my sister, esteemed sister cannot take up the matter.
Let it be adjourned, we will table, let it be simply adjourned. No, let it be simply adjourned.
This matter before any other bench without one of us. No, Mr. Justice.
I made for the first time a content in this case, and I thought, lordship is not taking up. It is a fit case for contempt. There
No,
are
that's
cases,
okay.
no, what I find, there are cases where a writ petition has been filed. With all respect, great respect, writ petition. I think it's a total violation of the court's order, because your lordship has termed as a confirmed employee. As a confirmed employee to them, they are not provisionals. They now take the plea of reverting back to the position as a provisioners. Anyhow, my lord, let it be simply adjourned the case. We will see it later on.
So we'll have to write not before.
No, your lordship can write not before and not to fix any date. If necessary, we'll go for register and we will mention it for automatic. I am deeply obliged.
Supplementary item 55 for motion.
My lord, instruction was sought for in this case. তাহলে কি দিলে আমাকে দিব না আলো কি আছে My lord. My lord, yes, I am not the person enquired. My brother was enquired, my lord. My lord, if not required, my lord, then
It's a premature petition. He has an apprehension, lordship. But he
Right.
is a relative of the declared foreigner.
yes.
Yes, we will go, as per the procedure, lordship, he cannot, but at the moment, he is not, we are not looking for him, lordship.
ভাল লাগিছে পঢ়ি। মূৰত কাপোৰটো লৈ যাম মানে ডিচেঞ্চি কওক গ্ৰেভিটি কওক মানে বিউটি কওক গোটেইখিনি ফুটি উঠিছে
The petitioner has expressed apprehension that pursuant to opinion last order para 2
My lord, at page 28.
and page 28. The border police is searching for him. And accordingly, by order dated 3/12/2025, in order to inquire into that aspect of the matter, was searching for him, though he was not the proceeding in the said FT case number 10 of 2015. Accordingly, the court, by order dated 3/12/2025, the court proposed to inquire into that aspect of the matter. Stop. Next part. Accordingly, the learned standing counsel for the FT and border matters has produced a copy of written instructions dated 8/12/2025, issued by the senior superintendent of police in bracket border, which is Morigaon, expressing that the border police were that the proceedee public declared foreign national in the, as per opinion dated 2/7/2025 was Mohammed MD Mohammed Hussain Ali, son of Ruhil, RUHIR, Ruhir Miyan, Miyan. Of, resident of village number 1, Khula, Khula, Bhuyan, PS Mayong, in the district of Morigaon. And that a memo dated 4/7/2025 was received to apprehend the said declared foreign nationals. Full stop. Accordingly, it is reported that no person named Muhammad Abdul Hussain or the petitioner is being searched for. Next, the said instructions dated 8/12/2025 is made a part of the record. Along with 2 enclosures made part of the record. Next paragraph. In view of the said instructions dated 8/12/2025, as the Senior Superintendent of Police within bracket border, bracket to Morigaon, has expressed that petitioner is not being searched for, in the opinion of the court, no, there is no ground to apprehend that the petitioner would be taken into custody in connection with an opinion which appears to have been passed against his brother. Next paragraph. Accordingly, as in view of the said instructions, the petition stands closed. Okay.
Declare.
Item 56 for motion.
May I please, your lordship? My lord, this is an ex parte order, my lord. My lord, the
last order is, my friend is supposed to satisfy this court lesson in this last visit. Notice,
Please come again.
Lordship, on the last day when the matter had come up, Lordship, we had our objections because the ex parte order is of 2009.
Yes.
So notice was not issued that day, supposed to
Yes.
satisfy the court on that ground.
Okay. Yes.
regarding that, my lord, the petitioner, my lord, at the age of 13 years in the year 1995, went to Sipsagar, my lord, and worked as a maid servant in one house, my lord, namely, my lord, Babul Barela. And thereafter, my lord, in the year 2005, he returned to his original place at Nagaon, my lord. Because of that, he has no knowledge about the case, my lord. My statement at page 3, para 3, my lord. And my lord, since 2005, as of now, he is, my lord, is staying at Nagaon, my lord. And recently, my lord, on 11/8/2025, the police of the concerned police station, Julia police station, visited the house of the petitioner. And thereafter, he came to learn that a case has already been, my lord, ex parte against the petitioner. But my lord, regarding service of notice, my lord, at page 33, kindly come to page 33, my lord.
Something is wrong.
The service of notice.
Something is wrong. When you say that your name is Amran Ali alias Muhammad Amran Ali,
Yes,
he can't be working as a maid servant. Name appears to be a male name. He can't be working as a maid servant.
work in the house of my lord.
No, but we
Babu
understand, we find it very difficult to understand.
Yes, my lord. My lord, he worked in the house of the
No, whatever the,
maid. Yes, my lord.
look at your language. This is something which you have incorporated. You said that he was working as a maid servant.
Is my lord wrongly written, my lord.
So alias for the name we understand. Amran Ali alias Muhammad Amran Ali.
Yes, my lord.
But now
A
male
male
alias
fellow,
female,
Yes.
this is also we'll have to now tackle.
Regarding service of notice, my lord, the page 35.
Thereafter, in the year 2005, he returned back. 2005 updated notice proceed. He returned back. 2018 notice, what did he? He going to address this something.
Oh, my lord, the matter, although the matter was, my lord, the expertise judgment was passed on 30/4/2009. The petitioner has no knowledge regarding the expertise opinion, my lord, judgment. And my lord, that service of notice that was not really served upon the petitioner, my lord. So, my lord, he may get a opportunity, my lord, to adduce his evidence before the tribunal. The report of the service of notice, my lord, clearly, my lord, says, my lord, he was not available. Page 35, my lord.
Lordship, as per the affidavit in the writ petition, Lordship, at paragraph 3, he states that he was 13 years of age, but that seems to be a wrong statement because his date of birth is sometime in 1977 and he ought to have been 18 years at. I have just calculated, Lordship, from the age, he's 48 years now. At page 21, Lordship, he states he's 48 years. So his date of birth should be 1977. And at paragraph 3, page 5, he states he was 13 years when he was working there in the year 1995.
Just a moment. In 2025, he is 48.
Yes, Lordship.
Nineteen 77.
Yes, Lordship.
Yes.
So at page 5, paragraph 3, his statement that he was 13 years does not seem to be correct. He ought to have been 18 years then. The petitioner, Lordship. Then, Lordship, that inquiry was held in the year 2003.
Yes.
The address he gave is correct, the one of his employer. He left that place in 2005, knowing very well that he has an inquiry pending against him. He never informed the authorities, Lordship. It is his statement at paragraph 3 that he left in 2005 and returned back to his original village, Lordship. At the age of Lordship, 18 years, he knew there was an inquiry pending against him. 2003, the inquiry took place. 2005, when the notice was sent out, it is correctly written that he is not available there because 2008, he had already left in the year 2005. So notice not being served properly because he never informed the authorities, Lordship, that he has changed his place of residence. May I bring Lordship to the Tribunal's order 1964, Lordship? 5F, Lordship. 5F, Lordship, may I read it?
Yes.
If the proceedee has changed the place of residence or place of work without intimation to the investigating agency, the process server shall affix a copy of the notice on the outer door or some other conspicuous part of the house in which the proceedee ordinarily resides or last resided or reportedly resided or personally worked for gain or carries on business and shall return the original to the foreigners tribunal from which it was issued with a report engrossed thereon or annexed thereto stating that he has so affixed the copy, the circumstances under which he did so, and the name and address of the person by whom the house was identified and in whose presence the copy was affixed. In this case, Lordship, the owner where he worked has said that he is not there anymore. So fixing of the notice does not make sense there. If he knew about it, he left it. The owner said that he is not there anymore. So the notice returned, Lordship. And it went back to the tribunal. And he has just now stated he knew about the proceeding. So that means all along he has ignored the proceeding, Lordship. He has intentionally avoided appearing before the court. And now he cannot take the plea that I have no idea, I did not have ignorance or playing ignorance about the ex parte order. When all along he has played with it, Lordship.
Yes.
So Lordship, my submission would be that there is no infirmity with the order of the tribunal, Lordship. He himself has not, despite knowing he had the opportunity, he did not appear. And today, after so many years, 2009 order, Lordship, we are already after about 20 years, he's before this court praying for a remand, Lordship. Lordship, that it cannot be allowed, Lordship. This would be my humble submission. Lordship, in fact, 5A also goes very well with the petitioner, Lordship. It says the notice shall be served at the address where the proceedee last resided or reportedly resides or works for gain, and in case of change of place of residence, which has been duly intimated in writing to the investigating agency by the alleged person, it shall be served at such change address by the FT. Had he informed Lordship, we would have sent the notice to the changed address, which he has failed to do so.
But Mr. S.A. Ahmed, learned counsel for the petitioner, also heard so from the respondents. The submissions of the learned counsel for the petitioner and the learned standing counsel for the FT and border matters is concluded. Court is inclined to peruse the records. Just accordingly, this is the matter on 10/12/2025 for passing of orders in the matter.
Oblige.
Item 57, supply item 57 for motion.
Am I appeal, Your Lordship?
Yes.
A second round litigation, my lord. Earlier remanded back, my lord, with the direction to the respondent to conduct inquiry through the SP Home Department and also examine the voter list 66/85 and examine the Kazi, my lord. But
Yes.
by order dated 24/9/2025, again declare her as a foreigner, my lord. Page 97. In this case, my lord, father, grandmother, and Kazi adduced evidence, my lord.
Where is the opinion?
Page 97.
Page?
97.
So,
24/9/2025.
but Mr. A. M. Ahmed learned counsel for the petitioner and so also for the respondents. Opinion dated 24/9/2025, page 97. Asked by so-and-so, case number so-and-so, reference ERO number so-and-so. They were declaring the petition to be a foreigner post 25 to 97th Street. Notice returnable in 4 weeks. Extra copies within 2 days, copy the records following email address of the learned tribunal. Next, prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection, 10 days time to take bail of rupees 5,000 for the satisfaction of Superintendent of Police within bracket.
Goalpara.
It was Goalpara. This is Dr. Fox, Somerset of.
Oh my God.
Item 58.
In this case, my lord, a petitioner was picked up on 24/5/2025, and at present, my lord, he is holding center 7th Assam Battalion, Saraikola Pukrajan, pursuant to expiry order dated 19/6/2012, my lord. A petitioner belongs to indigenous Muslim people, my lord.
You're charging 2000.
On
12
2012,
now.
my lord. Page 24.
This case would have to be dismissed in limine.
79 years old, my lord.
No, whatever be, but you got notice, you appeared, and then you did not take steps.
Para 10, I have stated, my lord, what happened in this case, my lord.
Para,
Para 10,
para 10.
yes, case 10.
This is wonderful. Why don't you accept and accept this advice?
My lord, I don't know, my lord, what happened in this case, my lord. And he has no any issue, my lord, also. And his elder brother is declared as Indian, my lord. On page 45. One of the brother, my lord, Jomiral.
We don't know whether he's the brother or not. Did your brother disclose the name in this opinion at page 45? Did your brother disclose your name as his brother?
No, my lord. He has not filed any written statement also, my lord.
Then how do you connect?
Yes, sir. Father's name appear, my lord, in this case. Brother's case, my lord. Appear of PS 46, my lord.
But this opinion is first in point of time.
Sister কথা বলছি। কাগজ রাখি পেলে দিস ইয়ার মেকআপ কল করলাম না
In which paragraph of this writ petition, you have disclosed the name of your family members?
Yes, my lord. Apera 2, my lord. Mother name also, Apera 2. And in the notice, my lord, father name appears as Darajuddin, my lord, Borpathar village. In the brother's case,
That is not the reason for us to smile.
my lord.
The reason to smile is the page 45, which you made us read. Did you read this opinion, page 45, before filing of the writ petition?
Yes, my lord.
Mr. Ahmed, have you read this opinion before filing it? No. And this has caused the damage to your writ petition. Come to page 48. Last 4 lines of the first paragraph. Please read it loudly. He is filing his so please read loudly so that I can refresh my memory.
Which paragraph, my lord?
Page 48, first paragraph, last 3 lines. His sister,
45, no? This reference, his reference was expertise, so later on appeared and mock application limitation. Page 48, no?
paragraph, first paragraph, third line.
Last 3 lines. Yes. He is filing his epic so his sister Muhammad Marajan also received notice from so and she has been declared Indian so
9 para 2, you don't have a sister. You have a brother because you read the first line of the opinion. But since you did not read the entire opinion, you don't know about your sister. Sir, we'll take a break and come back.
Sister, sir.
No, we are not interested in whether she has been declared Indian, but your family is not complete. Then you are borrowing names from here and there, that means. The difficult part is reading. Drafting is very easy. Drafting is easy. There's something called for
And next week, and next week. Publish. Otherwise, my lord, in the meantime, I may be allowed to file additional affidavit. My lord, yes. Additional affidavit. Yes, yes. All right.
Upgraded item 36.
Yes, Lordship, he, for the time being, Lordship.
Item 37, upgraded item.
In this case, the petitioner was deported, rather pushback, we don't know. The state has filed an affidavit, claiming that she was handed over to the BSF. Thereafter, it speaks nothing, it doesn't specify, what has happened thereafter. It's a very vague one, that's been filed with the state. Perhaps now that BSF has to respond, or the para, 9, my lord. It was filed, my lord, on my lord, date 25/11, it was served on me, my lord. 25th of November, it was served on me. It's filed by one Nivedita Goswami, my lord. She is the Joint Secretary, Home and Political, my lord, Department. It's number 3.
Baroda. Union of India Lordship. Union of.
Lordship. Lordship.
Otherwise, Lordship, I may allow to communicate it to MR Odhikari Lordship. This matter are handled by him Lordship. Yes, Lord. Or KK Parashram.
25/11/25, my lord. That's served on me, my lord. 11/25. Hola, the lord.
Maybe Lordship, Lordship.
Lordship.
Lordship. Lordship. Union of India can have
Time being item 36, upgraded.
Lordship. Lordship. That is not correct, no? He was, no, he was called for the purpose of inquiry, we have said, no? And in fact, he was called over phone, WhatsApp, in WhatsApp also he was, my lord, informed, but he did not respond. And that is why, my lord, logic has seen paragraph. But for the purpose of inquiry, can be. Lordship, kindly also see para 6, my lord. Rest करो ना। कोटे कैसे दे फोटो कैसे दे मैं हेडी नहीं और नहीं नहीं रेस्ट करो ना मैं कराता हूँ सही है ऐसे तो हम मेरे थोड़ा काम করে বুদ্ধ মানে হেয়ারিং করা তোর মানে হেয়ারিং করতে Lordship.
See, I probably like it. You are rather moving that everything, it's the matter of resolve. So there is nothing which is called that they wanted to put the matter, they don't know how to be free. It's not there. Complete 55.
But page number 60, 45. Yes, yes, no. But paragraph, Lordship has seen para, in fact, he was not alone. He had his Lordship. Lordship.
Hey, that is the commercial dispute.
But whatever.
It's not the work of the place. They are maintaining a record of it, and therefore everything person is free. But the entire transaction.
But it happened there, but the thing is that out of their, because of their will, they have willfully done that. Kindly see. He was not arrested or he was not detained, and for the purpose of inquiry, he was called, at we have under section 173 of NSS, the police has the power to make the preliminary inquiry.
See, I have Mr. Kavita is sitting next to you. Some client did not pay you 100 rupees years back. They done a stop job. The client did not pay you 100 rupees. Now, can you always, instead of the information, or you can then expect this part,
I'm incompetent.
Complaint pass, considering the complaint, the preliminary inquiry was done. Lordship, I got the point. I got the issue. Lordship may, let me examine, Lordship may kindly take it up day after tomorrow, let me examine. But commercial it to be 10, 12. 10, 12. They are talking. RPS,
Upgraded item 38.
Yes. Yes.
Lordship, in item 38, my lord, I'm addressing the court through VC.
Oh, sorry, there's some disturbance coming up. We cannot take up the matter. This has to be without one of us.
Lordship, in item 38, my lord, I'm addressing the court through VC.
You will have to switch off your, low down your tone of your speaker, it's echoing. We cannot take up the matter.
Very well, my lord.
It has to be without one of us. We cannot take up your matter. It has to be without one of us. You have to switch off your, low down your tone. You have got, you can understand us, you can listen, you can hear us. This matter, we can't take it up. All sides, including Mr. A, all sides are represented. Mr. A. Fukar, learned counsel for the applicant, appears through video conferencing. Next panel. List the matter before. This matter, we can't take it up.
We can hear, I can hear, my lord. I am for respondent number 65, 60, 65, 66, and 67.
In a bench without one of us, within bracket, Honorable Mrs. Justice S. Jahan. This is the matter before. This bench cannot take it up. It goes to another bench without one of us.
My lord, your lordship, this matter may not be taken up, cannot be taken up, but lordship may kindly fix a short date, lordship, that can be done.
We can't do it because the, it will be the registry who will do it. Please move the registry, they will give it.
Okay. Actually, partially, we have no objection to the appeal for demarcation. They could have done the demarcation.
Mr. Saikia, we can't take it up.
Yes, Lord. Extension of the hospital is necessary. Extension of the hospital, because there is the robotic operation, then there is cancer and heart. No, that's I'm making this submission. The court cannot take up the matter. Matter only to satisfy.
You can make all these submissions before the court, which can take up.
Yes, yes, yes. Not
This undesirable obstruction in between causing some difficulty or inconvenience
No,
to the
no.
court, to
This
the
is-
court more than to the lawyers.
No, this
So
is,
unless we can see the judge, honorable judge, it becomes difficult to address.
okay.
and I am not.
It can be kept on the right hand side because it's obstructing the vision. Your lordship will find it difficult to see where the lawyer, who is addressing.
No, we thought that many people may not like to see our faces.
The case is reverse, man.
Reverse.
Minor.
We have to take it in everything.
Because lawyers have to, as your lordships are aware, man.
Switch it to. Yes, now we have dislodged.
My your lordships are aware that the lawyers have to read the judges. So reading.
I don't know. I got an impression somehow that people don't want to look at my face.
Okay, madam. Obliged to
Now
lordship.
it's very comfortable, man.
Comfortable.
Okay. Thanks. You're the first man to say you're comfortable.
But I was thinking from we are also comfortable. Last 10 minutes, I was thinking, moment I get an opportunity, instead of making a submission on merit, I'll make a submission on this.
Good.
Obliged, Lord.
Obliged.
We'll make a submission before the court.
Yes, madam. Before the appropriate court.
Yes, man.
Upgraded item 39.
file করছো নি কেন? May I please your lordships? My lord, there is a my lord, delay continuation, my lord. Today, my learned friend has filed an objection affidavit, my lord. Just we have received the same, my lord. My lord. My lord, actually, the delay, initially we have preferred an appeal, my lord, within a time. But my lord, later on, it has come to, my lord, during the course of the hearing, that the certain part is required to be challenged, my lord, of the impugned order. That's why, my lord, this second writ appeal, there is a considerable delay, my lord. My lord. Mhm. 4 to 8, man, 4 to 8. মানে 12 minute I may not be here, minute. সন্ধ্যাৰ পিছত ল'ব। That was 15 minute. Mal. Much. Oblige, madam.
Upgraded item 40.
May please your lordship. My lord, here in this case, the review petition, we have filed an IA. My lord, the IA has been filed, praying for allowing to remain on bail, my lord. And that was filed because although the petitioner was appearing before the police regularly, but suddenly police before the date, my lord, of fixed date, police was asking him to appear repeatedly by phone, and therefore on apprehension that he may be detained on appearance, and that was filed, my lord. So at this stage, my lord, we are not insisting on the. My lord, review may be taken up at any other date, my lord. I am not at this stage prepared to. Twenty-one, my lord. My lord. গোয়ের প্রথম হলো কি হবো? বুধবার, হ্যাঁ? 9 তারিখ। আজি হলো? আজকে তারিখ? আজকে আপনার 8। হুম? 10 তারিখ। 10 তারিখ। My lord, it may be on 11, my lord. 11. My lord, 11 is hearing day. My lord. Hearing day, huh? My lord. Develop life. Develop.
Upgraded item 41.
May it please your lordship. Your lordship, this application is for seeking employment of Miss Tilottama Hazarika as respondent. As per the direction of the Honorable Court, by order dated 26/5/2025. Your lordship, we have annexed that order in page number 10 of the implement petition.
The minor child of the applicant is presently with Miss Tilottama Hazarika, Tilottama Hazarika. And therefore by filing this interlocutory application, the applicant seeks to impede her as respondent number 5. Next. You take notice of the fact that by order dated 25/6/2025, passed by this court in the connected WP Criminal 5/2025, the court had recorded the submission made by learned counsel for the respondent number 4. We had taken notice of the stand taken by the respondent number 4 in the affidavit in opposition that the concerned child is living with her maternal aunt, Tilottama Hazarika, prayer made in this interlocutory application stands allowed. Next paragraph. The applicant shall file a
Yes, your lordship.
What has happened? When you're updating things. This application, the data player for the handling of the. Now you have one data player for a new level. Now we are having. After that, you have to find another application for asking for a rental of the. The city custody. There's no deadline against the respond of right to. In this, your agency is regard to. The planning is given problem.
Your lordship, so far as the amendment of cost title is concerned.
You pay your cost, he has told you what is happening.
Once a month. Once a month.
Upgraded item 42.
May I please, your lordship? Lordship, I have for correction in the synopsis. In the synopsis part, impugn order has been wrongly spelled out here. So it should have been 03/08/2023, but instead of that correct date, it has been recorded as 30/10/2021. SC Dasanal.
I studied this information. Paid for. Synopsis.
Yes.
Contains the date of the period that's 2010-2021. Instead of very yes. The details about the necessary correction in the synopsis of the and the rest.
Well, before the court must. Well. Obliged, much.
I just got six as the last item, my lord. 60, my lord. Second is the last item, 10 floor.
That's why we have to mention item 59 lordship, supplementary lordship. Pass over for the day lordship. And may be taken after. Due to some problem of lordship, my mother has been admitted in the hospital lordship. Two weeks lordship.
Item 14 for admission.
May I please, your lordship? My lord, impugn order at page 33. My lord, at page 34, the relevant portion. May I read, my lord? DW1 is the opposite party, OP for short, Miss Mallika Khatun, wife of Abdul Mannas, resident of so-and-so. The OP has produced and exhibited some documents in support of her Indian nationality. Exhibit 1 is the certificate issued by the Gaubura, Moirabadi. The Gaubura has proved the contents of this document. Exhibit 2 document, Gaon Panchayat certificate, my lord. It was not proved by the author. It is stated here. So it is not accepted. Exhibit C is a voter list of 1970 containing the name of Moizuddin
that is the father of the petitioner, my lord. Exhibit D is the voter list of 1965 containing the name of Moizuddin and Joyton Nessa, father and mother of the petitioner, my lord. Exhibit E is a computer copy of Jamabandi of surveyed village of Moirabari, where the name of Moizuddin is found stuck off. So this document is not accepted in favor of the office Indian nationality. And Exhibit F is a voter list of 1989 containing the name of OP as Milika Khatun, not as Mullika Khatun. Now, my lord, the learned tribunal below, my lord, stated here, I have gone through the entire case record and verified all the documents submitted by OP very carefully. Although the OP has claimed that she is an Indian citizen, yet I am not satisfied to believe her as Indian on the following reasons. A, although the OP has said that the name of her father is Moizuddin, the name of her mother is Joyton Nessa, and the name of her paternal grandfather is Faizuddin, yet the OP has miserably failed to prove her as the daughter of the above mentioned father and mother and grandparents by dint of any believable link documents. So, my lord, I want to establish first, my lord, whether there is any link document with the father, mother. But to establish the link document, my lord, the Gaubura certificate and his deposition of Gaubura may be taken into consideration, my lord. Gaubura certificate is at page, my lord, 51, my lord. In this Gaubura certificate, my lord, the name of the husband is mentioned, my lord. The name of the husband is mentioned, my lord, not the father. But in the deposition, my lord, of the Gaubura, my lord, DW2, that is at page 26, my lord, of my petition, my lord. May I read, my lord? Page 26. Oh, sorry, my lord. Deposition. Yes, madam. Page 26. What I shall state shall be true. I know the opposite party. She is of our area. The name of the father of the opposite party is Moizuddin. The name of the grandfather of the opposite party is Faizuddin. I know the opposite party since long time. The opposite party had own landed property. The opposite party was married with Abdul Mannas, son of Chandu Bepari. The opposite party and the husband of the opposite party are residents of the same village. Exhibit A is the certificate issued by me. Exhibit A1 is my signature. That is the Gaubura certificate. Exhibit B is the Gao Panchayat certificate. Exhibit C is the voter list of 1970 in the name of father of the opposite party. Exhibit D is the voter list of 1965 of the parents of the opposite party. Exhibit E is the computerist Jamabandi copy of the land in the name of the father of the opposite party. The opposite party is not a foreigner. She was born here. That is Assam. Court has put some question, my lord, to which he answered. I do not know the date and year of birth of the opposite party. The approximate age of the opposite party is 50 years. That means, my lord, although in the Gaubura certificate, the name of the father of the petitioner was not there, but in his statement, my lord, the Gaubura has clearly stated, based on the document that is 1965 voter list, 1970 voter list of the petitioner's father, my lord, that Moizuddin is the father of the opposite party. Faizuddin is the grandfather of the opposite party. Similarly, my lord, although it is not reflected on the judgment, my lord, to establish link with the father, my lord, I want to show another thing, my lord, that is the Jamabandi copy, my lord, at page 47, my lord. Jamabandi copy of the land, page 47, my lord. Page 47 is the relevant portion, my lord. In column number 10 remarks, Ungo, as per order dated 18/5/1993 of the circle officer from the Chitha, the name of the serial number 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18 has been mutated in place of serial number 1 on the basis of inheritance, that is so and so. My lord, here, the serial number 1 which is mentioned here is Moizuddin, my lord, which is at page 46, my lord. I have stated that in bold letter, my lord. Number 1, Moizuddin, and the serial number 10, my lord. Serial number 10 is the petitioner, my lord, Milika Khatun. It is reflected on the Jamabandi copy, which was exhibited before the learned tribunal as exhibit E, my lord. The learned tribunal below, my lord, did not consider the same, my lord. Perhaps maybe due to oversight, my lord. And that order, my lord, it was passed in 1993, my lord, much prior to the case, my lord. My lord, here I want to point out another thing, my lord. So the land. 1989, my lord, with my husband, my lord. That is at peace, my lord. Sorry, my lord, 54, my lord. Number क्या है? Yes, my lord. So, my lord, the learned tribunal below ought to have taken into consideration the Jamabundi copy, my lord. But they have not taken, my lord, into consideration. So, so far, the link with the father is concerned, my lord. So, by dint of Jamabundi copy, my lord, it can be established, my lord. First thing, my lord. And the second thing, my lord, here, in the B column of the judgment, my lord, at page 34, my lord, the OP herself has stated in her deposition that she is 50 years old. If that be so, her year of birth is 1966, and she said in deposition that she was married in the year 1990. As such, it is proved that she was married at the age of 24 years. So, while she was at her father's residence till her age of 24, accordingly, her name should have enlisted together with her father and mother as voters in any voter list of her father's residence or village. But the OP fails to produce any such voter list containing names of the opposite party and the mother and herself in the same voter list as voters. My lord, I have stated in my petition, my lord, at paragraph number 19, my lord, page 12, my lord. May I read, my lord? The petitioner begs to state that on perusal of the impugned order dated. Yes, my lord. My lord, here,
Not even disclose the names of your brothers.
yes, my lord, that is there, my lord.
Here, you, at page 20, you don't even know that you are, that you are one of the pata holders of this land.
Yes,
You merely say that the photostat copy of land record is enclosed herewith. The land record in the name of your father, recorded in the year 1971. That's
Yes,
all. You don't say anything here.
yes, my lord, it was the Lekuna, my lord. Otherwise, my lord, the name is in the document, my lord. The
And when
petition,
we read documents, we don't find a connectivity. You see, we'll show you.
yes, my lord.
You just shown us your voters list of 1989.
Yes, my lord.
Look at page 55.
Yes, my lord.
First entry, Chandu Bepari,
Yes, my lord.
Pita, Sadhak.
Sadhak.
Come to page 48. Serial number 2, which is struck off. What
Yes,
is the
ma'am.
name? Chandu Bepari,
Yes, my lord.
Pita.
Pita Mahiuddin.
Yes. So how do you connect these two people? They must be two different people.
Maybe, my lord.
Correct, because through one, your husband is there. Your
But
husband is
that-
the son of Chandu Bepari, and your brother is also Chandu, but you don't say these things in your written statement.
My lord, here, I'm showing that number 1, my lord, Moizuddin, to link with his father only.
Understand?
Yes, my lord.
So you want us to read only one part of the document, not the other part.
Yes, my lord. Regarding this, I have to ask my client, my lord. Because that Chandu Bepari and this Chandu Bepari may be different person, my lord. Because the
But
father
you
name
don't
is
show
shown
anything.
different.
It is your burden to prove. You don't prove
Yes, my
anything.
lord, yes, my lord.
There's not even a not, you see, we are surprised to know here that your parents had 17 children.
That is,
From this Javamandi, at least 17 we can read, the others which. Correct. So 2 to 17 is your siblings. Your name is at serial number 17. No, not 17. Your name is
10,
serial
my
number
lord.
10.
10, my lord.
So before that you have 8 other siblings, and the name of none of them appear with your parents.
My lord, 12 are there, my lord. The remaining are different person, my lord. 12, as legal here, 12 are there here. Anyway, my lord,
I don't know. 13 also I see Pita Mohizuddin. If you say different man, we can't, we are not contesting it.
Mohiuddin is there, my lord. Mohiuddin and Mohiuddin is different person, my lord. It looks very same, my-
Mohizuddin.
yes, my lord. Mohiuddin and Mohiuddin. That is different, my lord.
But then on death of Mohizuddin, 11 to 17 have been impleted. Their Namjari is for 11 to 17. If they are different, how can?
My lord, the mutation order, my lord, so far the petitioner is concerned, my lord. At Ungo, my lord, that is there, my lord. Here 11, 12, 13, 7, 8, 9, 10.
Then is Mohizuddin. Mohizuddin. I don't know, say number 1.
Only 12 are there, 12 brother sisters.
One is MAI, one is MOI. And your link certificate on which you are banking,
Yes, ma'am.
both the Gaon certificate and the Gaon Panchayat certificate,
Yes, ma'am.
both have state emblem embossed, so they go. So therefore, which is the document which remains to prove you as your daughter of your father? How do you link yourself with your father?
My only document is, my lord, here. So far, the document here is concerned, my lord. Only the link, Jomabundi copy is, my lord. Otherwise, that Gaugura certificate is in the name of, against the name of husband. My lord, my lord, can it be do like this, my lord? It may be remanded to the tribunal, my lord. There they can, my lord, establish that, my lord. Otherwise, it is a fixed case, my lord. Because in the, although they have document, my lord, the learned engaged counsel, the tribunal, my lord, they have maybe, my lord, due to some inadvertent mistake, my lord. The document is there, my lord. one chance may be given, my lord, to the petitioner, my lord, to establish her case, my lord.
Same. So. Thank you. Separate is one line. Who's there? What the big. Is it true? Definitely. What is exhibit one or exhibit A? What is that document?
Gabura certificate money,
Congress certificate.
51 that page. My lord, may I point out one another thing, my lord? At page 40, my lord, regarding father name of Chandu Bepari, my lord, this document was periodic
But it
Heras
doesn't-
Patta.
Page 40 doesn't help you because this is not an exhibited document.
That was of 1971. Yes, my lord.
But it's your wisdom.
Yes.
Not even you have proved this. You have also not proved the material which was more important. You have not proved the order of mutation by which mutation was made in lieu of your father. So therefore, your father's connection to you has not been proved. You are merely showing us an entry in the Javamandi and saying that please accept him as my father. But the order of Namjari is not there. Your inheritance to your father's legacy is not there.
My lord, that is why I am praying.
You see,
for
what is the issue before the tribunal? The issue before the tribunal is whether you are the daughter of an Indian citizen and whether you are a citizen of India. The matter of inquiry before the tribunal was not whether you are the seller of the land in question. And therefore, you can't start with Javamandi.
I understand that, my lord.
Javamandi will only show your title to sell.
Yes.
Because the Namjari order says that in lieu of so and so, by way of purchase and possession, Khorida Dakhala Hutbe. In lieu of so and so, the name of so and so is entered. That is the only entry you have proved.
No, my lord, by Uttoradhikari Hotre, by his father's name, yes. Person. Khorida Dakhala Hotre, yes, my lord.
The entry which you have proved is the entry of cancellation of your name.
Now, that is why I am praying before your lordship, my lord. Kindly remand back the matter, my lord, to the learned tribunal, my lord, and let the petitioner, my lord, place his case fresh, my lord, so that otherwise, my lord, she is an Indian citizen, my lord. There is, it is admitted, my lord, that that is procedural lacuna, my lord, there is that, my lord. But, my lord, being layman, my lord, she was not in a position to understand that level, my lord. Whatever Sanghas Council was suggested, my lord, accordingly, she has gone through, my lord. So, my lord, kindly one opportunity may be given to the petitioner, my lord, so that she can place the case, my lord, properly, my lord.
Yes, Mr. Sharma.
There is no information in the opinion purpose in learned tribunal lawsuit. First, lordship, I am just reading para 26 of this Sarvan was one page lordship. 2005 SCC law. 2005 5 SCC 665. Para 26. There is good and sound result.
Just a moment.
Yes.
Yes, Lordship. There is good and sound reason for placing the burden of proof upon the person concerned who appears to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, the place of birth, name of his parents, their place of birth, and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A1B of the Citizenship Act. All these facts should be necessarily within the personal knowledge of the person concerned and not of the authorities of the state. After he has given the evidence on this point, the state authorities can verify the fact and can then leave evidence in rebuttal if necessary. If the state authorities dispute the claims of citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first this evidence on the associate command. This is in accordance with the underlying policy of section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving the fact is upon him. Lordship, so here in this case, Lordship, if we see the WS Lordship, there is nothing in respect of his her date of birth. Also, name of his parents has been mentioned, but name of father is mentioned Lordship in the WS, but name of regarding her mother's name, he is totally silent, Lordship. Apart from that, Lordship, her grandparents' names also not mentioned in the WS, Lordship. And Lordship, and here, although he is relying in evidence, Lordship, 1989 footer list, here only kidding is that my name is enlisted in the voter list of 1996 era 11 under 83 number in LSC and serial number 74. And Lordship, if we see the evidence part, Lordship, at case particular is not living Lordship, rest of the function is just 22. Fourth query, Lordship, page 23. I could not remember in which year I started sport. My mother's name is Joyton Nasa. It is about 5 years of death of my mother. I do not have uncle and Lordship. Here, what Prosity has stated that he did not remember his year date when he casted both, Lordship.
23, 82. Yes. Yes, doctor. Iraura. Yes. But no, what are we closing? There is no link at all.
Yes, I have seen also. One important aspect is Mr. Rafi, the proceeding himself did not exhibit any document, Lord Sir. Gabra has exhibited his certificate, Lord Sir. Yes, sir, yes, Lord. Yes, Lord Sir. Okay, that's it.
A Rashid.
Passed by the learned member, page 33, Foreigners Tribunal, 5th Morigaon, in there are 4 numbers, huh? MFTJ number so and so. Case number so and so, new number, so and so, old number, DN case number so and so. Thereby declaring the petitioner to be a foreigner of post 25 3 1971 stream. Next one. On receipt of notice of the proceedings, the petitioner had appeared and filed a written statement. And in support of her evidence, in support of her case, the petitioner has examined herself as DW1. One Ruhul Amin as DW2 was the government Gaunpura, and one Safia, SAFIA, Safia Khatun, wife of Idris Ali, as DW3. It may be stated that the petitioner has not exhibited a single document, and all the documents which have been, all the six documents that had been exhibited on behalf of the proceedee, public petitioner, was done by DW2, the government Gaunpura. Full stop. Next para. However, the court is constrained to note that in the impugn opinion, the petitioner, the learned tribunal has not discussed the evidence of DW2 and DW3. Next para. At this stage, the learned standing counsel for the FT and border matters has submitted that as the petitioner had not exhibited any document, comma, she has not been able to prove her link with the projected parents. Moreover, comma, it is submitted that the certificate by the Gaumra within bracket exhibit A EXT full stop A bracket closed and the Gram Panchayat certificate within bracket exhibit B are not admissible in evidence in view of the fact that both the documents contain state emblem, comma, being the pillar of Asoka, ASOKA, pillar of Asoka. Moreover, comma, it is submitted that by none of the documents, comma, the petitioner has been able, none of the exhibited documents, comma, the petitioner has been able to link herself with the projected parents, comma, more so because the written statement filed by the petitioner does not conform CUN-FORM conform to the mandate of law laid down by the Supreme Court of India in the case of Sarbananda Sonowal versus Union of India and others. Two thousand 2005. 5 SCC 665. That is 2. This is about 4 P. As the petitioner has not disclosed the name of a mother or any other siblings. Next paragraph. Though we find force in the submissions of the learned standing counsel for the FT and border matters, comma, but it is too well settled that the Foreigners Tribunal is required to consider all the pleadings and evidence on record. Full stop. Whatever worth was the evidence of the PW2 and PW3, comma, the learned Foreigners Tribunal ought to have discussed the ought to have considered and or discussed this said evidence. Next one. In view of the non-consideration and non-discussion of the evidence of DW2 and DW3, comma, court is of the considered opinion that the same vitiates the order dated 28 to 2000, the opinion dated 28 to 2017, passed by so page 33. Next paragraph. Having arrived at a conclusion that the said opinion is vitiated due to non-consideration of the evidence of DW2 and DW3, comma, the court is inclined to remand the matter back to the said learned Foreigners Tribunal for a fresh opinion in accordance with law upon considering the pleadings and evidence available on record. Next paragraph. as the matter is being remanded, the court has not examined and discussed the available pleadings and evidence on record. Next paragraph. The petitioner, who is duly represented by a learned counsel, shall appear before the learned member, Foreigners Tribunal, 5th, Morigaon, on or before 30 January 2026, without requirement of any fresh notice of appearance to be served on her. And by producing a certified copy of the order, wait for further order of the instructions from the State Learned Tribunal. Next paragraph. In the event the petitioner fails to appear within the time allowed, it will be permissible for the said Learned Tribunal to consider the petitioner as to be absent on call and pass a fresh opinion in accordance with law. Next paragraph. The writ petition stands partly allowed to the extent as indicated above. Next paragraph. The registry shall send back the records of the tribunal back along with a copy of this order to be made a part of record by the said learned tribunal.
My lord, one prayer, my lord, my humble prayer. The petitioner may be allowed to submit document if,
That can't be.
at least, my lord, by calling the witness, my lord, if possible.
That can't be. Because a failure to give evidence does not give rise to a right to deed evidence. Then in every case, people will come and say that, no, this evidence I forgot. Please give me one opportunity.
Yeah.
And no suit proceeding or any criminal trial will ever end. Because we always have a brilliant man standing behind. One advocate will come, he'll say, no, I did not know, I made a mistake. Another lawyer will come, then, no, I did it, but I only added 1, 2 I left out. There will be third advocate again coming. That can't be permitted. And there's no pleading that your advocate made a mistake. You have not even disclosed the name of your lawyer. You have not alleged that he has committed any wrong.
Yes, my lord, I'm not. Always, my lord.
But we can have, we can give you an opportunity.
Yeah.
You can renew the prayer and we'll pass orders to reject it.
Reference was initiated in the year of 1998.
1998, yes.
Yes.
No, but this is.
This is also
tribunal should know.
19 years.
Time limit is.
In earlier, earlier we said that matter is remanded back. There at the end, you had the learned tribunal having noticed that the reference was made in the year 1998, we hope and trust that the learned foreigners tribunal shall make an endeavor to conclude the proceedings within a period of 3 months from the.
If there is doctor, because as per E14 of the Foreigners Tribunal order.
3 months, 90 days.
Here lordship 60 days was prescribed as per law.
Within 2 months.
Dispose of the case.
Within 2 months
Of the receipt of reference
from the date of receipt of records. No, from the date of from the date of appearance, i.e. 30 January 2026.
Item 15.
There is There is no representation on behalf of the petitioner. Full stop. Records show that the petitioner remained unrepresented when the matter was previously listed on 29/10/2025 and on 7/11/2025. Accordingly, by order dated 7/11/2025, this court had adjourned the matter for end of justice by observing that if on the next date of listing, the petitioner is not represented, adverse orders would follow. Next one. Accordingly, as the petitioner remains unrepresented when the matter was called, his petition stands dismissed for non-prosecution. Next para. The registry should send back the records back to the concerned learned tribunal along with a copy of this order to be made a part of the record.
Item 16.
May I please, Your Lordship?
Yes.
Lordship, the opinion is at page 34, Lordship. Then
You the records? Yeah.
page 35, Lordship, the operative part.
Yes.
The opposite party has submitted written statement containing inter alia that he is a citizen of India by birth and the permanent resident of Ward number 2, Gauripur, PS Gauripur, subdivision Dhubri, Sadar, district Dhubri, Assam, and the Election Commission of India issued an electoral photo identity card in favor of him. The name of the father of the opposite party, namely Gedu Sheikh, appeared in the electoral roll of 1966 and 70, issued by the Office of the Deputy Commissioner, Dhubri Election Office, Dhubri, Assam, and his all family members' names are also appeared in the electoral roll for the year 1997. The opposite party stated that he has landed property in the name of his grandfather, Anat Sheikh, which is his ancestral property bearing patta number 1277 in Gauripur in the district of Dhubri, Assam. Hence, the opposite party has stated that he is a citizen of India and tried to dismiss the case. Now, the point for determination is as to whether the opposite party, namely Muhammad Abdul Rahman, is a citizen of India or foreign, within the meaning of the expression foreigner as defined in the Foreigners Act 1946. As per provision of Section 9 of the Foreigners Act 1946, the onus of proving that he is a citizen of India is not a foreigner lies upon him. Now let us find out as to how far he could discharge his burden of proof to prove that he is not a foreigner. I have gone through the evidence as well as documents very carefully. In this evidence, the opposite party reiterated all the statements as stated in the written statement, which I have discussed above. I have heard the argument advanced and for both sides. In support of his claim, the opposite party has produced and exhibited the following documents. Exhibit 1 is the electro photo identity card in the name of the opposite party, namely Abdul Rahman, son of Gedu Sheikh. Exhibit 2 is the PAN card in the name of opposite party, namely Abdul Rahman, son of Gedu Sheikh. Exhibit 2A and 3A are the certified copies of the electoral roll of the year 1966 and 1970 of village Ward number 2, Gauripur, Moja, Gauripur, under 34 Gauripur LSC, which contains the name of only Gedu Sheikh, son of Anat Sheikh. Exhibit 4A is the certified copy of the electoral roll of the year 1997 of village ward number 2, Goripur, Moja, Dhubri, Goripur under 24 Goripur LSC. From this document, it transpires that the name of one Amina Bibi, a 60-year wife of Gedu Sheikh, Fazle Rahman, son of Gedu Sheikh, Abdul Rahman, son of Gedu Sheikh, Pierre Banu Bibi, wife of Abdul Rahman, and Sabdul Rahman, son of Gedu Sheikh, are enlisted. Exhibit 5 and 6 are the NRC of the year 1966 and 1971 of village 106, Goripur, ward number 2, district Dhubri, which contains the name of Gedu Sheikh, son of Anat Sheikh. Exhibit 7 and 8 are the Khatian of 8 number village, Goripur town part 2, district Dhubri, where the name of Anat Sheikh, son of Ibrahim, was recorded. Exhibit 9 is the certified copy of the draft chita of village Goripur town part 2, district Dhubri. From the above exhibited documents, exhibit 1 is the electrophoto identity card, where the electoral name was shown as Abdul Rahman and relations name as shown as Gedu Sheikh. This certificate was issued on 1/10/2013. That is, this document is post to 25/3/1971. Moreover, electrophoto identity card is per se no proof of evidence. Such a document would not only have to be proved in accordance with law, but must be corroborated by other substantive evidence to prove citizenship. Exhibit 2 is the PAN card in the name of Abdul Rahman, son of Gedu Sheikh, but no reliance can be placed on this exhibit as a valid piece of evidence, as the same is not proved by the authority concerned. Exhibit 2A and 3A are the certified copies of the electoral roll of the year 1966 and 1970, respectively, which contains the name of a single person, namely Gedu Sheikh, son of Anat Sheikh, and as such, no conclusive opinion would be drawn in absence of names of his other family members. Moreover, the wife of Gedu Sheikh, namely Amina Bibi, aged 60 years, is conspicuous by her absence. And Exhibit 4A, it is also seen from the record that the opposite party has failed to prove any voter list since 1970 till the year 1997, that is about 27 years. So I do not find any continuous existence of ancestors of opposite party till this date, which is an essential ingredient to prove the citizenship of a person. So, Lordship, this is the only lapse, Lordship, that he have not produced all the voter list of all the years before the tribunal, Lordship. This is the only thing, Lordship, that actually he is staying here at Guwahati, Bhaskar Nagar, and all his family members belongs to Dhubri. He belongs to Dhubri, Goripur. So, and he is just a rickshaw driver, poor family. He could not go to Goripur to collect the documents, Lordship. And once he went, he collected only few documents, which he produced before the tribunal, and that's why tribunal did not consider Lordship. He could not produce all the voter lists. But voter lists are there, Lordship. Still to today, his family, all the other family members are casting their vote. His brothers, his wife, everyone.
Yes. Who is Anat Sheikh?
Anat Sheikh is his grandfather, Lordship. And Gedu Sheikh is his father. He has ancestral property also, Lordship, belonging to his grandfather, which is still joint property.
So what is the document which connects you to your projected father?
Our voter list also is there, Lordship. 1997 voter list is there, his name is there in the voter list. That is at page,
Apart from electoral roll, any other document?
like in the voter identity card. Voter identity card also is there, Lordship. Annexer 1, page 13.
Fine. Hmm. Hmm. No. Poca palmana, sir. Lux, Okay, মানে দেখো বাকিটাকে কখন আকারে মাঝে সলিউশন এখন যেটা হচ্ছে দেখো পাহাড়ে বাকিটার মাঝে সলিউশন মাঝে কিন্তু কিন্তু রিলেশন তো দেখা যাচ্ছে কিন্তু 66 হবে 70 এখন না কত আছে হ্যাঁ Witness, no witness except him, DW1. Accept the petitioner. Lordship. Because all people they say go to. This voter list is there, Lordship, of 1966 and 70, Lordship. 70. Lordship. No, Lordship. ¿Cómo? Pero me cortan. Yes, Lordship, because you cannot produce all the voter list, Lordship, you cannot submit all the voter list, Lordship. So if your Lordships, I mean, then we can file an additional affidavit if he is able to bring all the voters list, Lordship. Because it's there, voter lists are there of all the years, they are casting their vote till today. Except him, his other family members. Watch.
After 1970 to 1997, there is a discontinuity.
Yes, Lordship.
That was discussed in the opinion box. And apart from totally, there is nothing to do with this project further lordship. The name reflected in the total list of 1966. Apart from footerlist lordship, only after 1970 lordship, there is a discontinuity of 27 years lordship. And that was discussed in the opinion lordship. And apart from voter list lordship, there is nothing to link with his project at Father. If in lordship, voter list also lordship, there is could not find any link lordship with his project at Father lordship. How and lordship, one important aspect is that lordship, when his father died, when lordship parents are alive or not, that was not mentioned. Even lordship, name of her parents also not mentioned in the written statement lordship. I think I have seen the again, okay, lordship. Number 4. Yes, lordship.
Is there, Lordship?
What Adismia cases stated lordship in 2023 for DLT 246 para 14. We are constrained to observe that mere claim by suspected person by 2023 for DLT 246.
2023.
For DLT 246. Repetition number 2370 of 2023.
Yes, what does it say here?
Lordship, para 14. We are constrained to observe that a mayor claimed by a suspected person by referring to a voters list, claiming a person therein to be his father is not a conclusive proof, and that by doing so the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voters list relied upon this actually the father of the person who makes the claim will have to be substantiated with further materials acceptable in law. So lordship, here in this case, lordship, although proceeding has submitted voter list lordship, but other documents is not there lordship. And lordship, no other family members comes forward lordship to depose on behalf of the proceeding lordship. And lordship, what Kotian has been lordship here. Exhibit 7, Lordship.
Yes.
Okay. One, Lordship, land document, Lordship, অসম অস্থায়ী বন্দোবস্তি এলাকা রায়তী সত্ত্ব, Lordship, that was in the name of Anath Sheikh, Lordship, it was issued in the year of 2015, Lordship. So, Lordship,
2015.
yes, Lordship, this is the document.
Certified copy was obtained, Lordship.
Which page?
Page, Lordship, from LCR, I am saying, Lordship, this is document, Lordship.
Criteria number 8.
Yeah, exhibit 7. Criteria number 8, yes, Lordship.
Criteria number 8. Yes. Criteria number 8. This is issued in 2015.
Okay. By this document also, Lordship proceeding cannot able to establish that he is the grandson of this Anath Sheikh, Lord.
Can you see? Sit.
So, Lordship, we are here under certiorari jurisdiction, Lordship. So, we are only to see whether the opinion of the tribunal is good or bad, Lordship. So, Lordship, my humble submission is that there is no infirmity in the opinion
First party Lanark Tribunal.
Yes, if this is a document issued in 2014 and 17, then it could you sustain your case?
Yes, yes.
Lordship. Lordship, I may be allowed to file additional affidavit, Lordship. I'll bring the documents. Because he did not produce those. No, but those voter list, Lordship, and land document, if any. Lordship. Okay. Residential. Just stay. Must be.
Lordship. Lordship.
I'm addressing the members of the bar. We don't have time to take up any of the matters. We'll rise because there's a meeting at immediately now.
Last all the instruction was called for.
Which item?
60 man. More than 6 months.
60, okay.
Yes, ma'am.
You have got instructions? Kimber.
Opinion is of 2009 Lordship.
We'll take it up tomorrow. That's it. Charlie. Charlie. Due to positive time, the matter could not be taken up today. As the learned counsel for the petitioner expresses urgency in the matter, list the matter on 9/12/2025. To take this back, we'll take it tomorrow. Yeah. I love it. Just show it to Mr. Ali so that he understands what the nature of problem is.